litigation is a means to achieve the goals and objectives of our clients.
I want to briefly talk about a new bill, not a new bill, but a continuing bill that's already been submitted to committee in the New York State Assembly for consideration. This bill is entitled An Act to Amend the Public Health Law in relation to the removal of cases, contacts, and carriers of communicable diseases who are potentially dangerous to the public health. This bill itself calls for, when a state of emergency is issued by the governor, the removal and detention of carriers who are or who may be a danger to the public health of others. This bill raises very big constitutional and individual liberty concerns, and in any event, it would be deemed unconstitutional by any judge who cares about individual liberty. It states here that upon the determination by the governor or an executive branch person or authority, by clear and convincing evidence, that the health of others may be endangered by a case or contact or carrier or a suspected case or carrier of a contagious disease, that the commissioner may, in its discretion, if this person or group poses an imminent and significant threat to the public health, they may order the removal and detention of a person or group of such persons by issuing a single order which identifies the person by name or reasonable specific description, or a reasonable description of the group that is to be detained, in a medical facility or other appropriate facility or premises. For the state to use its power to involuntarily commit a person or a group of people for what may be a suspected case, or from a disease that may pose imminent or significant health to the public, puts too much power in the hands of the government. This does not even clearly and specify what diseases we're talking about, which is a departure from the current statute on the books, which this bill seeks to amend. But when read most liberally, it gives the government authority to detain people or groups of people who have suspected cases of suspected illnesses that may pose an imminent threat and significant threat to the public health. Patently absurd and grave overreach. Now, what's most striking again about this bill is that there is no due process afforded to the group of people or person who is sought to be detained by the government before their detention. So a government agent may knock on your door or post a sign in your community that says you all got to report to the bus station on the corner of, X Avenue and Y Street, and we're going to take you to a medical facility or a field hospital or God only knows where, because we believe that you may pose a threat. Under traditional law and under the law as it currently exists, in order to detain a person or a group of people who have a communicable disease that poses a specific threat, the government has to petition a court before the person is taken into custody. And then only after a hearing on notice and due process, which is the hearing itself and the evidence adduced and a judge making a ruling, only after that hearing on notice is held will a person be deprived of their liberty by the state. This is a huge departure from that. That this bill does not require that, which it should, and which I think it must. So it goes on here to state at paragraph 4, here we go. So a suspect carrier who is detained pursuant to this provision shall be detained until such time as they no longer is or will become contagious. Why is this problematic? Well, I think it's problematic because ultimately, with a disease like SARS or COVID-19 that we're faced with now, we don't know if you will ever not become contagious or will again become contagious. Why? Because we're even hearing that the vaccines are only good for 6 months. So if I'm in a high-risk group or I'm in an area where there's a cluster, then ultimately the government can hold me until I can prove or until it's established that I will no longer become contagious. And the only way to no longer become contagious is to get vaccinated every 6 months or whatever it's going to be so that you cannot contract the disease or give it to someone else. Paragraph 7 provides that when a person or group is ordered to be detained for a period greater than 3 business days, and any member of the group or the person requests to be released, the governor shall or must make an application for a court order authorizing them to continue to be contained or retained by the state. And this talks about the process and how long the duration is. But here it says that at line 51, in no event shall any person be detained for more than 60 days without a court order authorizing the detention. So the government can't keep you forever without presenting you for a hearing. Now, interestingly, when you get down to paragraph 12, we're going to go over this in detail a little bit later, but it says that at line 31, such person or person shall, upon request, be afforded an opportunity to be heard. Meaning, if a person asks for it, they will have a hearing at their request, at which time they can present evidence and be represented by an attorney and have their due process rights provided to them and afforded to them through a proceeding. Now, it says, but this provision does not apply to paragraphs 2 through 11. So the due process rights don't apply to paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, and 11. So at paragraph 7, where we're talking about the length of your confinement, there is no due process right. You cannot request a hearing. The only people who can request a hearing is the state if you're going to have to be in their custody for a longer period of time than provided by the statute. That's a problem. Now, paragraph 8 provides the notice requirement, which says that a copy of any detention order, again, this is an ex parte order. This is an order that a government agency promulgates by itself. It's not even before a court. It's not like a FISA warrant even, or a warrant, or some kind of issuance of a warrant in a criminal proceeding, where you go to a judge to get the authority to act against the rights of somebody. Here, you just have ultimately a bureaucrat signing their name to a piece of paper. And this detention order gets posted, either served on you to the individual, or it gets posted in a conspicuous place to a group. So that's where you'll show up outside and it'll be posted that, if your name is X, Y, and Z, or if you were at such and such a place, or if you're in this group of people, then you got to appear for a bus ride to take you away. And you'll have a hearing about it some other time. Very dangerous statute. Very dangerous. So the notice advises that they're being detained have a right to request their release from detention, and including the instructions. We already know that, you can request to be released, but the state can keep you for 3 days. And if you ever get a hearing, that's terrific, but I don't know how expedited that's going to be. And ultimately, you're in confinement, I believe, before you get your hearing. That's the way the statute is set up. At line 41, it says that the notice, the order of detention, must say whether or not they request relief from detention. The governor must obtain a court order authorizing detention within 60 days following the commencement of your detention. So that's got to give you a lot of great feelings when you know that you're going to be stuck away for at least 60 days without a court order. Paragraph 9 says that a person who is detained at a medical facility must be safe and not act disorderly, and you should not attempt to leave the facility or attempt to leave. I don't even know what that means, to attempt to leave. Maybe that means you actually physically have to try to walk out the door, or maybe it means you try to exercise your constitutional rights by getting a judicial order to get you to leave. So now what happens to you once you are confined? We get to paragraph 12. Here's all the happy joy stuff that, now that they got you in what they believe you to be a safe place, not impacting or potentially might be hurting other people or the public at large, this is what they do to you. So they can seek to enforce their other rights that they deem necessary. They're not really limited to the rights in this statute. But they can also require you to remain quarantined at home or at a premises of a person's choice that's acceptable to the department, and under such conditions and for such a period as will prevent transmission of the contagious disease or other illness, to require the testing or medical examination of persons who may have been exposed to or infected by a contagious disease, or who may have been exposed to or contaminated with a radioactive or toxic chemical. So again, we're going now back to the government and saying, please, don't put me into this medical institution or field hospital. I can be safely quarantined at my house. The state has the authority to make that determination. And ultimately, who knows what government official is going to be making that decision about you and where you are or are not allowed to stay. And again, we see this very troubling language about an illness that may pose a threat to the public health. Okay? Again, this may word. It's not like you've been proven to have, a specific disease like typhoid or tuberculosis, where there's a very clear statute about what happens to people with this particular disease. Now we're talking about diseases or illnesses that may pose a threat, not even defined. Too arbitrary, too capricious, not constitutional. This bill should never get out of committee as written. Then moving along, it says that it may also require an individual who's been exposed to or infected by a contagious disease to complete an appropriate prescribed course of treatment, preventative medication or vaccination, including directly observed therapy to treat the disease and follow infection control provisions for the disease. So what we're talking about here is that the state may require you to become vaccinated. And that's something that some libertarians and other groups may not necessarily agree with. However, the government does recognize its own constitutional and moral, perhaps, limitations, where it provides at line 32, you will have an opportunity to be heard about whether or not you are going to be given any treatment or not. Now, that is one saving clause here to this particular statute, which I think I made my views pretty clear on it. But at least you're getting an opportunity to be heard. Now, that is really still a bit of a slippery slope, because forced vaccination is something that many communities are skeptical about, and I think civil libertarians have good grounds and basis to say, listen, the government can't compel me to vaccinate myself or my children. And what this bill is saying, you'll have an opportunity to be heard, but that puts the ball in the court of the court, or a arbiter body or an administrative hearing officer to make the determination as to whether or not you will or will not get vaccinated. Now, if a judge orders or a court orders that you must submit to this vaccination, then your refusal to do so will necessarily mean that you could be held indefinitely, because we have to get to that stage where a person can only be released if they no longer is or will become contagious. Here's the statute that this bill wants to amend, and that's 2120, the Communicable Disease Control of Dangerous and Careless Patients Commitment. Here we have a statute from 1953, and there's been some litigation on the statute, but not a heck of a lot, but enough good law to give us some guidance going forward. This statute says as follows: whenever a complaint is made by a physician to a health officer that any person is afflicted with a communicable disease or is a carrier of typhoid fever, tuberculosis, diphtheria, or other disease, and is unable and unwilling to conduct himself and to live in such a manner as not to expose members of his family or household or persons with whom he may be associated to danger of infection, the health officer shall investigate the circumstances alleged. After the investigation, and it's determined that they are a menace to others, then they will file a complaint that will be brought before a magistrate. And then after due notice and hearing, upon well-founded evidence, the officer of the court, the magistrate, may commit the person to a hospital or institution established for the care of that person. Now, this provides for ample protections under the due process clause, because it gives the person an opportunity to be heard before the state comes and takes them away. Much different than the proposed law that we just looked at. Now, one interesting case that came out on the statute here is Rappaport versus GM, a 1997 case. Says that in a proceeding to involuntarily hospitalize a person, there exists a constitutional right to counsel because the outcome of the proceeding may result in that person losing his or her physical liberty. So, yes, there's a clear right to counsel, but I think more important here is the court's recognition that any involuntary hospitalization is necessarily a person losing his or her physical liberty at the hands of the state. And we will not let that happen without due process. And that's where this law currently sits. Thank you for bringing this to my attention. I hope you found this somewhat useful and interesting to see, because every day, especially under the guise of this coronavirus, and that we've been living in a state of emergency for at least 9 to 10 months, that your liberties are being attacked every day by even well-meaning legislators. But I'm glad you brought this to my attention. I'm happy to discuss these issues with you. And this is extraordinarily dangerous, this particular law that's being proposed. And we'll see what happens.